Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I'd like to talk about a couple different issues that arise essentially in immigration law, other areas of law too, but in immigration law when we are talking about a particular law that passes and that then changes the penalties or changes something negatively when you commit the act or when you try. Okay, now the reason I bring this up is because under the U.S. laws, really, and constitutional laws, they have what's called retroactivity. And I bring this up for a reason. Retroactivity has to do with when a particular law is passed, and after it's passed, it makes a penalty of something which was not previously a penalty. Okay, let me just give you an example before I get into when what I want to talk to about what's called the Fleuti Doctrine and retroactivity. Let me give you an example so you have a clear understanding of how this applies and could apply in many immigration situations that occur. And one type of situation that would occur, of course, would be where someone commits a crime. So let's say in 1993 somebody committed a particular crime and they received a sentence and so forth, and then they were put into deportation proceedings. In that particular case, there's various scenarios, but in that particular case, let's say that they then applied for what was called 212C relief, okay? And there were certain things you needed in order to apply for it, but just assume that they qualified in 1993 for 212C relief when in deportation proceedings. Now, let's say, give it exact example, except we'll change the time period. Let's say, again, the crime was committed in 1993 and they served their sentence, but let's say they were not immediately put into deportation proceedings. Rather, let's assume that for the next 5 years they weren't, and then let's just say that they were driving one day, had a broken tail light, they were stopped, the policeman sent notification or cross-reference the databases, found out the person had the prior crime, and now they get put into removal proceedings because in 1996 they came up with what's called IRA, which made all kinds of changes to the immigration laws and made all kinds of crimes aggravated felonies, which didn't used to be, and it also repealed 212C relief. So now this exact person who committed the crime in 1993 and who was not immediately put into deportation proceedings, as they were called at the time, but because of something that occurred, the broken tail light, as an example, he's now put into removal proceedings, and now he can't apply for 212C relief because it has been repealed, and therefore he gets a deportation order and is deported for, essentially for an aggravated felony, let's say, for the rest of his life. Now, if you can see what I'm referring to here, you have a person who committed a crime back in 1993, and at the time it was committed, when he was put into deportation proceedings, he did qualify basically to get his green card back and to stay in the country. However, after the passage of IRA, which repealed 212C relief, he no longer qualified, and he didn't qualify for any of the new kinds of relief, cancellation of removal or whatever it is, and was issued the deportation order. Well, that is known as retroactivity, and retroactivity is not constitutional under the U.S. Constitution because it attaches new penalties. It doesn't give notice. So what happens is somebody who commits a crime before IRA, and essentially has notice of what the penalties will be, is now hit with something completely new years after the crime was committed and is penalized because of it. That's retroactivity, and that's not allowed. The only way it is allowed is if Congress passes a law which specifically states that it is retroactive. Now, just so you know, even if they do that, if it is a penalty and hits the person hard, basically, we can fight it. Okay, the immigration attorneys can fight it and go up and so forth. Sometimes when something's retroactive, it's to the benefit of the person, and then of course, you wouldn't fight it. Certain citizenship laws making someone a U.S. citizen when they might not have been before. However, the reason I bring this up is because it is a very important part of immigration law, and essentially anything that you are getting penalized for, if you get an immigration attorney who really knows the law and is familiar with the new enactments and so forth, timing is a very big issue. So the penalty, the deportation, the removal, the bars, all that stuff may or may not apply in your particular case if you analyze it, or it is analyzed in the terms of whether or not it was retroactive, the law being applied as retroactive. Now, the reason I started off giving that example about the 212C relief is, in fact, the lawyers argued after 1996, when people were being deported because they couldn't apply for 212C relief anymore, they fought the case, and they, of course, the way it is they lost at the immigration court level, they lost at the Board of Immigration Appeals, they then went to petition for review at the circuit courts, and then there was differing opinions all over the country at the different circuit courts, and it went all the way up to the U.S. Supreme Court that then issued a decision saying it is unconstitutional to retroactively take away and repeal 212C relief for people who committed the crimes prior to IRA and would have had that relief available. So essentially in 2001, after 5 years of fighting it and getting up to the Supreme Court, they then restored, they didn't actually restore 212C relief for new applicants, but if you happen to fall under the provision where you committed the crime prior to 1996 and qualified, you could then apply for 212C relief. Well, there's other avenues that as well that show that the 1996 IRA law is being applied illegally and unconstitutionally to other people. And in fact, there was a recent Supreme Court decision which essentially stated another area of retroactivity existed, which was unconstitutional. So let me just give you the facts of the case so you understand. Somebody committed a crime. It was in 1994. This person was from Greece, and the person wasn't even put into removal proceedings at the time, because at the time in 94, it wasn't considered an aggravated felony, and it may or may not have been made him inadmissible, but the fact remains he wasn't put into deportation proceedings. Well, he has lived here for essentially the last 30 years, and what happened in about 1998, or actually it might have been around 2000, he decided to go back to Greece, visit his sick mother, and then he came back to the U.S. And this was only a week that he was gone. Well, what happened is the officer at the port of entry who noticed that he had a crime in 1993 classified him as what was called seeking admission. Okay, and the law as of after IRA, the law states that even if you have a green card and you come into the United States, if you have a crime that makes you inadmissible, then you are not a returning alien, but rather you are seeking admission, and therefore, because you're seeking admission, you need to show that you are admissible, and if you're not, you're going to be put into removal proceedings. And so sure enough, this particular gentleman was put into removal proceedings, and essentially to fast track what happened, the immigration judge denied the relief, denied the waivers and so forth for this particular gentleman, and went up to the Board of Immigration Appeals. They agreed with the immigration judge, denied him relief, and ordered him to be deported. They then filed a motion to reopen at the Board of Immigration Appeals, saying that he should never have been classified as seeking admission, that he should have been just a returning resident, because he was only gone a week, and prior to IRA, they had what was called the Fleuti Doctrine. And the Fleuti Doctrine is, if you are gone essentially from the United States less than 90 days or so and come back, then your intention to become or to stay as a resident and not to depart remains as is, and you're just allowed to come back in. So for sure, without doubt, prior to 1996, if this gentleman wanted to leave and go for a week to go visit his sick mother and come back to the United States, it would have been without issue. He would have been admissible because he wouldn't have been seeking admission. He already had his green card, and they would not have sought to determine whether or not that crime made him admissible or inadmissible, because under the Fleuti Doctrine, he was gone a very temporary period of time, and that wouldn't have even kicked in. But after 96, the Fleuti Doctrine was no longer applicable. In fact, after 96, after IRA, what has occurred is that when people are inadmissible under a particular crime, or they've committed a crime, then they are no longer just a returning resident, but in fact seeking admission, and therefore then come under the provisions of whether or not they should be put into removal proceedings. So again, he lost at the immigration court level, lost at the Board of Immigration Appeals level, and then the motion to reopen was filed, basically claiming ineffective assistance of counsel, that they should never have, the attorneys should never have admitted that he was removable in the first place. The BIA denied that motion. It then went up to the Second Circuit Court of Appeals. The Second Circuit Court of Appeals then agreed with the Board of Immigration Appeals and ordered that he was properly classified and that there was no constitutional errors of retroactivity. Well, that of course again conflicted with other circuits such as the Ninth Circuit, and so the U.S. Supreme Court took up the case to determine whether in fact a new penalty had issued and whether or not the IRA was being unconstitutionally retroactively applied. Well, it turns out that, the government was arguing that all he had to do was stay here and there wouldn't have been any problems at all, when in fact the U.S. Supreme Court said that's not the case. It is a great penalty to not be able to leave the United States, to visit family members, to go to weddings, to visit if your parents are dying or terminally ill, whatever it is a great penalty to not be able to leave. And that basically a new penalty was being issued because when this person left the United States, in fact, it was not prior law, prior to IRA that was being applied, but in fact it was post-IRA law regarding admission and inadmissibility rather than the application of the Fleuti Doctrine. Okay, I mean, had he left for 7 months, we wouldn't be talking here, because for sure then he would not have been a brief, casual, and innocent departure to allow him to come back without issue. So they ultimately ruled that it was an unconstitutional application of the law, that he should have been able to just leave and come back without being classified as an arriving alien and put into removal proceedings. And they essentially reversed everything that had happened up until that point, so that essentially this person will now be able to have all the removal orders vacated and will be a lawful permanent resident and will be able to come and go out of the United States, assuming it's for a brief time, without any problems. So a couple reasons I bring this up today. One, even if this particular issue, does not specifically affect you, but you have been, or you know someone who's been deported or is fighting removal proceedings right now because of a crime that was committed, and of course it had to be committed prior to IRA, which was pre-1996, then you want to make sure that the particular attorney you have is looking to see if there are any retroactivity issues, and also you can call me and set up an appointment. I'll be happy to give a consultation on the issue, and then you want to see, even if the person's been deported, if they were deported because of unconstitutional applications of this principle I'm talking about, it can be fought, and we can go back and do what's necessary in order to try to fight it. Now, also, what you see from the case I just discussed is that sometimes you have to fight a few battles to win the war. I mean, this guy fought the immigration court, BIA, went to the BIA again, then to the Second Circuit, then all the way up to the U.S. Supreme Court, and basically he was fighting for 10 years. Okay, there was a lot of fights to be able to stay in the country, but he fought it, and now everything's okay. So sometimes you can't expect to win it on the first go-around. In fact, the immigration court has no authority even to rule on constitutional issues of this manner, other than what comes down as precedents from the circuit courts and from the Supreme Court. Similarly with the BIA, Board of Immigration Appeals. But when, for example, I make the arguments, I have to make the constitutional arguments at the immigration judge level, at the BIA level, so that when it gets up to the circuit courts, and maybe when it gets up to the U.S. Supreme Court, they're not going to be able to argue, at least the other side, that I never brought the issue up and therefore they should dismiss it because it was never argued. So that's why we have to do it. Okay, so that will essentially conclude our video today on retroactivity and the Fleuti Doctrine. Again, if you like the video, click like, go ahead and subscribe. I do put out new videos about once a week, and we'll go from there. Okay, more on the coming videos. Thank you.